Foreign terrorist fighters have been defined in the Security Council Resolution 2178 as those individuals who travel to a state other than their state of residence or nationality in order to perpetrate, plan, prepare, or participate in terrorist acts or provide or receive terrorist training. The issue with this definition and the concept of FTFs is that while their regulation occurs mainly under the counter-terrorism regime, their conduct has to also be assessed according to the law of armed conflict. Much of the concern under the counter-terrorism regime is centered on what they may do upon return to their state of origin and how to handle them as a national security risk. Meanwhile, IHL focuses on conduct during war and ensuring that this is lawful and that those not participating in hostilities are duly protected. Under IHL, those who directly participate in hostilities on behalf of a non-state group in a non-international armed conflict, which is what most foreign terrorist fighters do, are considered to be fighters or unprivileged combatants. This means that they may be prosecuted for taking up of arms and for IHL violations. The issue is what regime of law foreign terrorist fighters would be prosecuted under and what conduct they will be held responsible for, and whether they should be held liable for otherwise lawful acts of war under the counter-terrorism regime. Courts have, however, demonstrated a certain amount of flexibility and have handled such cases quite well. German courts have held that both regimes apply and have prosecuted returning FTFs for their membership of a terrorist group as well as war crimes, applying both the IHL and the counter-terrorism regimes to their conduct. For instance, a German national who joined IS faced war crime charges for letting a Yazidi child she had enslaved die of thirst and was charged for being a member of a terrorist organization. Under this approach, FTFs are prosecuted for all acts which fall outside the conduct of hostilities under the counter-terrorism law and are prosecuted for acts committed in battle under IHL. This approach privileges the lex specialis IHL for acts during active hostilities and takes into account the counter-terrorism regime for all ancillary acts. In sum, an adequate compromise to the problem of which law to apply to FTFs.